Hello there, my name is Ian Freckelton. I'm what's called a Queen's Counsel in Australia, which is a senior advocate. I'm a judge in the Republic of Nauru and a professor of law and psychiatry at the University of Melbourne. And I have affiliations with Johns Hopkins University. I'm going to talk to you about expert evidence given about autism spectrum disorder. Let's commence by thinking together about the purpose of expert evidence. A Scottish case more than half a century ago, said that the duty of the expert witness is to assist the judge or jury, the fact finder, with the criteria for testing the accuracy of their conclusions. An English decision just 5 years ago set out a set of admissibility criteria, threshold issues which determine whether expert evidence is permitted. And again, as you can see, those criteria focus upon whether the evidence is likely to assist the court, whether the witness has the requisite expertise, whether the person is impartial, and whether there's a necessary level of understanding, knowledge, or experience that forms the basis for what the expert has to say. In the United States, the Daubert and Fry tests are the linchpins of whether an expert is permitted to testify. But at the heart of most systems of common law admissibility is the question of whether evidence from an expert will provide material assistance to a court. Experts give evidence about what they have seen or heard, that's evidence of fact. They give evidence that we all think of in terms of opinion, the inferences that they draw from the data that they have. And sometimes experts endeavour to give evidence of conjecture, which is impermissible. So how does this link in to evidence given by mental health professionals about autism spectrum disorder? The first point that needs to be made is that this is a specialist forensic role. It's much narrower than the broad issue of evidence about mental state. The second point is that it's much more than merely labeling a condition. It's one thing to say that someone has schizophrenia, but when one talks about a person being on the autism spectrum, it can be extremely diverse in terms of the impact that being on that spectrum has upon an expert's interaction with the world, the significance of their symptomatology, and how they experience triggers and stimuli. The challenge of the expert is to carry the listener into the world of the person with autism spectrum disorder and assist them to understand how that individual would have experienced a factual scenario and made decisions. The next issue for a person giving evidence about autism spectrum disorder is that most likely there are a number of comorbidities. They may include ADHD, fetal alcohol spectrum disorder, obsessive compulsive disorder, Tourette's, intellectual disability, personality disorders, but almost certainly they will include anxiety and probably depression. That involves a requirement for the expert to disaggregate the different comorbidities, but also to take account of how they interact and to form a perspective on the whole person and how the individual is likely to function in particular circumstances. So there's an educative role for the mental health professional in terms of provision of insights that may well be counterintuitive. In other words, contrary to the expectations that a person might otherwise form as to how the individual, the subject of the expert evidence, functioned This means that there are a number of challenges for the expert in terms of how to deal with the structures of the court and the requirements of the forensic role. What I'm going to do is to take you through a variety of scenarios in which mental health professionals are called upon to give evidence to assist courts in relation to autism spectrum disorder, and think through with you how they can contribute by reference to decided cases from various parts of the world. Let me start with the issue of whether a person's capacity for reasoned responses has been impaired by virtue of autism spectrum disorder. What we know is that the condition can affect a person's capacity for reasoning to a point where it may even exculpate them by removing criminal responsibility from the conduct in which they have engaged. Much more commonly, though, it reduces criminal culpability and thus is relevant to the question of the sentence that should be delivered by a court. In the South Australian case of the Queen and Peak, the accused was charged with manslaughter by criminal negligence of their mother. Justice Vanston accepted expert evidence that Peak was precluded by virtue of symptoms of autism spectrum disorder from appreciating the need for her mother's need for medical intervention. What had occurred was that the mother had died by reason of not receiving medical care, which manifestly was required. A clinical psychologist gave evidence that autism had impacted adversely on Peak's ability to appreciate the nature of the risks posed to her mother if her mother did not receive the medical care that was required, and that Peak did not respond with the urgency that someone else would in the context of this lack of awareness and insight. The case is particularly significant because the court found that Peak lacked the necessary mental element to be found guilty of the offence of manslaughter. So autism spectrum disorder resulted in a finding of not guilty altogether because of this lack of mental element that was intrinsic to establishing the charge that was laid against her. In a New Zealand case of Walker, the accused person pleaded guilty to a variety of computer fraud offences. He established a very sophisticated bot network, disabling antivirus software and causing havoc, in short. Justice Potter accepted on the basis of expert evidence that Walker had diminished understanding in relation to the nature of his offending, being unaware of the harm that his activities could cause, being immature to the extent that he was unable or failed to set proper boundaries for himself in relation to the conduct in which he had engaged. Again, this meant that he was discharged without actually being convicted, so a very light penalty indeed, based upon the expert evidence given in the case. In addition, expert evidence can be given about the reduced capacity of a person for empathy, for feeling with somebody else. If an accused person has a significantly reduced level of empathy, this can reduce how blameworthy they are for the conduct in which they have engaged. Recognizing this impels us to think further about the nature of individual responsibility and therefore what impact neurodiversity can have on a person's culpability for conduct in which they engage. Let me give you an example of a recent case from Victoria in Australia. Gray was a very intelligent man holding a doctorate in quantum physics, but he was charged with a range of sexual assaults. The argument mounted on his behalf was that he didn't really appreciate the impact of his sexualized behavior on others. And the main witness who assisted in this regard was a psychiatrist who explained that Gray was unable to appreciate the full impact of his behavior on a victim. A psychologist supported this contention, saying that Gray's autism spectrum disorder was a significant contributor to his offending and to the nature of what he did. In other words, his socio-emotional functioning was significantly compromised and contributed to the criminal behavior in which he engaged. Now, ultimately, and you'll see that this is a bit of a pattern in a number of the cases to which I refer, was found that Gray's autism spectrum disorder did not mitigate his culpability. Why? The main reason that one can discern in these cases is a preparedness on the part of courts in a variety of cases involving neurodiversity to accept the potential for contribution to mitigation, at least, in relation to autism spectrum disorder, but to be very hesitant to do so when it involves offences of sexual misconduct. It's a moral issue in which, as soon as such matters are raised, there's a real hesitation in permitting any reduction in culpability arising out of autism spectrum disorder, or for that matter, a range of other conditions, including ADHD. Let's move then to the utility of expert evidence when it explains or gives some insight into the consequences of conduct engaged in by a person with autism spectrum disorder. Now, what we appreciate is that autism can lead to obsessionality in both thinking and conduct. It can go to the utility of trying to deter a person by the imposition of punishment, and it can also mean that a conviction plays a more significant role in terms of the equanimity and well-being of an offender than it might do for a person without autism spectrum disorder. There's a nice example of this from a case in New Zealand in 2009, where an individual became absolutely obsessed about the state of the environment. He proclaimed himself a road safety activist and was outraged when somebody intruded upon space that he thought ought to be available for the public, became absolutely obsessed about it and caused damage. He was convicted and ordered to pay reparation and to do community work, and he appealed to a higher court. The expert evidence suggested that if Glover's conviction remained, it would exacerbate his alienation, despair, and frustration. And therefore, in essence, it would be highly counter-therapeutic. A psychiatrist supported this contention, asserting that the rigidity of thought and a cognitive inflexibility that were really intrinsic to Glover's mindset as a result of his autism meant that this was a precipitant to his offending. It was also observed that this explained his complete lack of remorse and his egocentricity and obsessionality. Ultimately, it was held on appeal that imposition of a conviction would have an effect that was out of all proportion to what he had actually done, and so a conviction was not imposed. Let me talk to you also about expert evidence going to an issue in respect of the ability of a person with autism spectrum disorder to be alert to, cognizant of social cues and dynamics that the rest of us are alert to and aware of, and which govern our behavior in a variety of social situations. Persons with autism spectrum disorder can be insensitive, or at least inadequately sensitive, to the risks posed by their conduct and to what is taking place in a broader context. They may get the messaging wrong. They may misunderstand, misconstrue. Now, this argument has been raised in a variety of contexts with mixed success. In a case in Victoria in Australia in 2016, there was an appeal that was brought against a decision of a lower court not to impose imprisonment when a person had fallen asleep at the wheel and caused both death and serious injury to somebody else when driving. A psychologist testified that Borg, who was 20 years of age, both had autism spectrum disorder and that his fatigue and his autistic functioning would have combined to reduce his self-awareness in the circumstances of his driving. The sentencing judge ultimately accepted that Borg would have experienced real difficulty in a prison environment, as well as the issues arising in the context of his offending, and was actually at risk of committing suicide if transposed from the world which was structured and with which he coped into a custodial environment. The Court of Appeal categorised the sentence that had been imposed upon Borg, which had been non-custodial, as merciful, but the court was not prepared to overturn it, holding it to be within the range. So the expert evidence resulted in the imposition of a sentence which was, one, merciful, and two, vastly less than would otherwise be imposed on a person without autism spectrum disorder. I've referred to difficulties that persons with autism spectrum disorder can have in terms of their awareness of the consequences of what they do. This has been particularly prominent in cases involving computer hacking and arson. Sometimes also the issue of the person's ability to appreciate what triggers are placing them under pressure can be to the fore. In a decision in Marinovich, in a case in New Zealand in 2020, Marinovich was found guilty of the murder of his mother by choking and hitting her with a hammer. The strange thing about this case was that Marinovich had a very close and supportive relationship with her, but she became ill. And Marinovich didn't have a cognitive or affective flexibility to deal with his mother's needs in those circumstances. And the stresses built and built, and he exploded in an atypical way for him, and in a way which just did not seem consistent with the kind of relationship he generally had with his mother. Marinovich was found to have autism spectrum disorder of a moderate severity, and that the effect of that was that he was unable to manage in the circumstances in which he found himself. The court also noted that he'd be particularly vulnerable in prison and that he had difficulty in expressing remorse in a way which is conventional. In other words, it was hard for the court to appreciate the depth of regret which Marinovich actually experienced. He couldn't ventilate it in the way which is conventional. So instead of receiving a life sentence, which would otherwise have been mandatory, he received a sentence of 14 years imprisonment. So no minor consequence, but nonetheless significantly less than would otherwise have been imposed. In the Australian case of Sokoluk, the issue of autism spectrum disorder was raised again. It took place in a very fraught context because there'd been terrible bushfires in Australia, much like the ones which happen all too regularly in California. And Sokoluk was convicted of 10 counts of arson causing death in the context of setting bushfires. And he was sentenced to over 17 years imprisonment. The issue in the case was as to his awareness of the likelihood of adverse consequences from his setting fires. And one of Australia's best-known forensic psychologists diagnosed Sokoluk with autism and mild intellectual disability that he described as having affected Sokoluk's social and adaptive functioning all of his life. He said Sokoluk's presentation, reasoning, receptive and expressive language are affected by the confluence of his autism spectrum disorder and decreased level of intellectual functioning. For example, he said that Sokoluk was a very concrete and literal thinker. Now, the language here is important and interesting because what Professor Ogloff, the psychologist, did not say was that Sokoluk was unaware of the dangers that he was posing. And in fact, Sokoluk took some measures to hide what he'd done and told a variety of lies about it in the aftermath. This left the sentencing judge with a very difficult situation. The charges were serious in the extreme. People had died. Sokoluk had held down employment for a period of time, but he most assuredly did have autism spectrum disorder, was obsessed by setting fires, and gave little heed to the consequences. Ultimately, a very heavy sentence was imposed on Sokoluk, and this probably arose from the fact that there was not clear expert evidence from a suitably qualified mental health professional that the condition of autism spectrum disorder significantly reduced the moral culpability of Sokoluk and significantly detracted from his ability to have some meaningful awareness of the likely consequences of what he did. Another issue, and this is one to which I have adverted already, is that imprisonment can have particularly harsh consequences for at least some people with autism spectrum disorder. Some individuals with it can adapt to the routine of a prison environment, others simply cannot. And there's been a very interesting series of cases in the United Kingdom in which individuals have been the subject of extradition applications to bring them from the United Kingdom to the United States to face very serious computer hacking charges. And the likelihood is that they would spend time in a supermax prison in the United States. The most prominent of this sequence of cases occurred in 2018, and it involved an individual called Love. He'd engaged in hacking, which resulted in a variety of cyber attacks on United States government institutions. The interesting thing about the Love case is that very sophisticated evidence was mounted on his behalf about the severity of his autism spectrum disorder. And one witness, well known in the area of autism, Professor Baron Cohen, expressed the unqualified view, in other words, the view from which he did not remove himself in any way, that Love might well commit suicide if actually extradited. He was already suffering from a variety of physical ailments, which were the product of stress, and the view of the expert witnesses, and there was a psychiatrist, a psychologist, and even someone from the United States explaining the nature of supermax incarceration, was that Love would become psychotic without the family support, which was the pillar of his ongoing functionality. Ultimately, the Court of Appeal in the United Kingdom was persuaded that it would be oppressive to extradite Love to the United States, and that the risks were so extreme of adverse consequences to him that it would be an inappropriate outcome. And so he remained in the United Kingdom. Another issue in terms of expert evidence in the autism spectrum disorder context is that it is easy for persons to misinterpret, misconstrue the way in which a person conducts themselves, their demeanor, their apparent indifference to matters when they have autism spectrum disorder. In those circumstances, it can be very helpful for there to be expert evidence from a suitably skilled mental health professional to disabuse of misconceptions to which a judge or jurors might otherwise be privy. Some courts have been receptive to such evidence being adduced, others have been less prepared to allow it. One of the classic examples in this case is a Scottish case of McGrady, which Lord Brodie observed of the individual, the focus of attention in the case, that he did not appear to engage with his counsel's questioning. He was abrupt. He gave the impression of being wearily exasperated at the questions he was being asked. Perhaps, to his credit, he did not seem overly concerned to present himself in a favourable light. You can see the problem. What is causing him to behave in this way? Lord Brodie ultimately accepted that his Asperger's syndrome may be the explanation for the way in which he gave evidence, but he said it may not. However, whatever the reason for his responding to questions in the way that he did, taking his responses as a whole, I have felt bound to conclude he was not a witness upon whom I could rely. This is particularly so when it came to his accounts of interactions with people. To an extent, this case is about the reasonable interpretation of what was said and done in a particular social context. You can see the problem. Lord Brodie was dealing with someone who was neurodiverse, who was behaving in an odd, unaccountable way, and he didn't have sufficient evidence to explain to him what was the etiology of this kind of behavior. It's really a case which highlights the need for counterintuitive expert evidence to explain what is otherwise inexplicable, curious, unaccountable, and which may well alienate a jury in particular, but also a judge, from the person when it ought not to do so. It doesn't necessarily follow that because a person with autism spectrum disorder is disengaged and apparently uninterested, that that's how they're really feeling. A decision in Western Australia, some of the same issues arose, and they arose in the context of whether a trial ought to be a judge-alone trial. And Justice McKechnie said, "My observation of the accused certainly confirms his behaviour is unusual. I'm satisfied he has an impairment due to autism. The question is whether his detachment from his trial process manifested by apparent non-responsiveness is primarily due to his autism." The accused also raises the possibility that his unusual personal characteristics may cause him some prejudice and that the jury are distracted by his behaviour or draw adverse inferences against him as a result of such behaviour. And Justice McKechnie ultimately was prepared to allow the trial to be before him rather than before a jury on the basis of the risk that there would be misinterpretation of the way in which the accused man was behaving. Let me just make a few concluding and brief observations then. Expert evidence in many criminal cases is fundamental about the effects of autism spectrum disorder upon an accused person's behaviour at the time of committing an offence, how they may behave in the courtroom, and what the effects of imprisonment may be upon them, or even the effects of imposition of a conviction. You'll recall the New Zealand case. The courts need assistance about the forensic ramifications of autism spectrum disorder. However, it is a specialist area of practice. Not just any psychiatrist and psychologist is adequately positioned to give the requisite insights to a court. Principally, the role of the mental health professional in this area is to be educative, sometimes to be counterintuitive, but mostly to enhance the capacity of a decision maker to understand the forensic ramifications of autism spectrum disorder. It's much more than provision of a mere diagnosis. That is no ticket to empathy or even to understanding. It's a matter of explication of the consequences of the disorder in the forensic context. Often the question is whether the particular individual's experience of the symptomatology of autism spectrum disorder was relevant to what they did or to other matters. Usually, this is in the context of a variety of comorbidities, and the question is whether the whole package significantly impacted upon the accused person's mental state. At the heart of this is the ability of the expert to enable the decision maker to understand the internal world of a person with autism spectrum disorder. Because it's in those circumstances that that level of awareness is enabled, that a court is placed in a position where it can appreciate what impact the autism spectrum disorder might have on what occurred at the time of the engagement in criminal behaviour, what's taking place before the court itself, and what impact the disorder might have in the sequelae in the post-court world. So that involves the provision of insightful information enabling that level of understanding. And a key part of all of this is that imprisonment can be especially oppressive, sometimes life-endangeringly so, for individuals with autism spectrum disorder. So that's been a short tour of the relevance of expert evidence about autism spectrum disorder in a variety of contexts in which persons come before the courts. I hope it engages you and has enabled you to have better understanding of the pivotal role of expert evidence that can be given by psychiatrists and psychologists in a specialized context. Thank you.